Welcome to the Employment Law and HR Podcast with your host, Alison Colley.
Hello and welcome to episode 166 of the Employment Law and HR Podcast. I'm your host, Alison Colley, and I run the firm Real Employment Law Advice, where we provide advice and assistance to both employers and employees. In addition to providing day-to-day advice to our clients, I also produce this podcast on a fortnightly basis and have been doing so since August 2014. So we've been around for quite a while. The aim of the podcast is to provide easy to listen to updates on employment law and HR for anyone who's interested in employment law and HR. And this week, I'm going to be focusing on an issue that was raised by a listener, actually, who contacted me with a question, and then we had a further discussion by telephone about it. And I thought it would be a really interesting topic to bring to you, the listeners. So I hope you find this week's content interesting. And if you do have any suggestions or questions for future podcasts, then do please get in touch with me. I'll be happy to include them. So without further ado, I'm going to get into this week's featured content. Now, the issue I'm going to cover today is in relation to without prejudice discussions and those discussions that lead to a settlement agreement. Now, you may be aware that a settlement agreement is one way of agreeing to terminate an employee's employment by agreement and to provide them often with compensation. And it usually includes some additional clauses. It's a common way for employers to try to resolve disputes or to head off issues that may be arising or to get around the problem of dealing with long and drawn out processes. So, for example, I'm seeing them used fairly frequently at the moment in relation to redundancy dismissals, where the employer wants to dispense with the need to go through a fair process or go through a redundancy consultation. They're going straight to making an offer of a settlement agreement where they're paying an enhanced payment to the employee, in return for which the employee is agreeing to leave and waive their employment rights. Now, the reason why this question about settlement agreements and without prejudice discussions came up is because there seems to be some confusion that's developed, or maybe people have sort of forgotten about the actual nature of the rule of the Section 111A of the Employment Rights Act exemption in relation to termination discussions. So I'll start from the very beginning. For those of you who aren't aware or just need a reminder, in 2013, the Employment Rights Act was amended to include a new provision, which is 111A of the Employment Rights Act, which provides for the confidentiality of negotiations before the termination of employment. And what this did was introduce a new statutory provision for employers to be able to have conversations around the termination of employment with employees without worrying about those discussions being brought up later on in some unfair dismissal proceedings. So what it says within the section is basically, evidence of pre-termination negotiations is inadmissible in any proceedings on a complaint under Section 111. This is subject to subsections 3 to 5. So in subsection 2, it says pre-termination negotiations means any offer made or discussions held before the termination of employment in question with a view to being terminated on terms agreed between the employer and the employee. Subsection 3 says that Subsection 1 does not apply where, according to the complainant's case, the circumstances are such that a provision, whenever made, contained in or made under this or any other act, requires the complainant to be regarded for the purposes of this part as unfairly dismissed. Then goes on to say at 4, in relation to anything said or done which in the tribunal's opinion was improper or was connected with improper behaviour. Subsection 1 only applies to the extent that the tribunal considers just. And then it says at number 5, subsection 1 does not affect the admissibility on any question as to costs or expenses of evidence relating to an offer which made on the basis that the right to refer to it on any such question is reserved. So in short, what that means is employers are open to have pre-termination negotiations with employees, and the employee will be unable to bring that up in relation to a claim for unfair dismissal unless the employer says something which is improper or behaves in a manner which is improper in the course of those discussions. And of course, if the employer makes that offer and says it's not admissible save for costs, then if the case goes to an employment tribunal later on, then the employee or the employer, if successful, can raise the issue in relation to costs. So it opened the door for employers to have more discussions with employees in situations where things like redundancies were arising or grievances were happening or some sort of dispute was taking place, and the employer wanted to have that discussion with the employee. And that's fine so far as the employee's complaint relates to unfair dismissal. And this is where I think some people are becoming confused about the Section 111A rules, because it only relates to unfair dismissal claims. Employees can bring into evidence those discussions if their complaint relates to something else, like discrimination, for example. And there are many employers and HR professionals who are perhaps unaware of this potential risk when they start those discussions. Now, of course, the employee has to have one of those other claims for it to make any difference, but it is something to be aware of. Now, the reason why the Section 111A amendment was made is because prior to that, employers were seeking to rely on the general without prejudice rules. Now, the general without prejudice rules are still available to you if you're trying to negotiate a settlement with an employee. However, they are more limited in scope than the Section 111A rules in that there needs to be a existing dispute for you to be able to rely on the without prejudice rule. Now, admittedly, many employers were using the without prejudice rule prior to the change in the law about settlement discussions anyway, and many were getting away with it. But there were some occasions where an employee would reject an offer made on a without prejudice basis and then bring a claim and then seek to use those discussions in evidence. This then led to the employment tribunal or the court considering whether that evidence could be used or whether it was covered by the without prejudice rules. Now, in order for a conversation to be protected under the without prejudice rule, if you like, there must be an existing dispute between the parties. It must be a genuine attempt to settle that dispute, and there must be an agreement between the parties to treat the discussions as without prejudice. And there must be no impropriety in the conduct of the parties during those negotiations. Now, the key problem in many instances is that there may not be an existing dispute between the parties. That means that an employer can rely on the without prejudice rules. So if, for example, you open up a discussion with an employee in order to terminate their employment, and let's just say they are absent due to long-term sickness, which is as a result of a disability, and then you, rather than go through a capability process with them, you go straight to making them an offer of settlement to terminate their employment and to compensate them for agreeing to sign a settlement agreement. If the employee rejects that offer and the case proceeds to an employment tribunal claim, then those without prejudice discussions are likely to be admissible as evidence by the employee, because I don't think that you would be able to say that there was an existing dispute there that you're genuinely attempting to resolve. A situation where you may be able to rely on the without prejudice rule is where an employee has raised a grievance against their manager for, let's just say, race discrimination, and the grievance process has been dealt with and the employee is still unhappy and has indicated that they're going to pursue a claim and pursue their rights in relation to that discrimination. In that situation, if you then opened up without prejudice discussions with the employee, I think you would be able to rely on the without prejudice rule so that those discussions can't be used as evidence against you later on, because you are seeking to resolve a genuine dispute between you, because the employee has indicated that they're unhappy and that they are going to bring a legal claim. It is, however, important to note that the mere fact of raising a grievance doesn't necessarily mean that there is an issue in dispute between the parties. It would require, in my view, based on the case law on this, the employee to indicate something more, that they were going to perhaps say that they were going to pursue a claim, or that they'd taken legal advice, or something further for it to genuinely be a dispute between the parties. In the case of BNP Paribas versus Mezzotero from 2004, the EAT dealt with this very issue, in which an employee was invited to a without prejudice meeting and made a settlement offer, and then subsequently refused the offer and made a claim for discrimination. And in that case, the EAT addressed the issue of whether the employee raising a grievance was enough to indicate that there was a dispute between them. And they decided that the mere fact of raising a grievance doesn't mean that there is going to be a dispute. That means the employer can rely on the without prejudice rule. So what do you need to take away from this episode of the podcast? Well, the first thing is to remind you about the history of the Section 111A rules in relation to settlement discussions, and as a reminder that they only apply in relation to unfair dismissal claims. So if an employee doesn't accept an offer and then makes a claim subsequently for unfair dismissal and discrimination, for example, then they could use that evidence of those discussions against you in the employment tribunal as evidence of discrimination. The second thing to note is that there is the without prejudice rule that's available for other disputes or other potential claims that an employee has, but you need to be aware that there needs to be an existing dispute for you to be able to rely on that later on, should you be unable to settle the case. Now, one of the reasons why I think perhaps people aren't necessarily aware of the difference in the rules, or have perhaps forgotten that they only have protection for unfair dismissal under the statutory rules, is because actually in the majority of cases there is the opportunity to reach a settlement between the parties, and often, especially if there is a pragmatic approach taken by the parties to the settlement discussions, they can reach a settlement agreement. And so it doesn't really matter in the long run if the employee would have had a discrimination claim, for example, because they have agreed to settle those claims. And so employers need to be mindful of that when they're going into discussions. It might be that you decide, actually, we can take the risk that they might try to introduce this as evidence later on by making an offer that's good enough for them to accept, or makes it more tempting for them to accept than to run the risk of bringing an employment tribunal claim. And of course, even if they don't accept your offer and bring a claim in the employment tribunal, the evidence that they produce in relation to those without prejudice or off-the-record discussions may not necessarily be enough to convince the tribunal that you have done something wrong. So, of course, that yes, they might be able to use that as evidence, but it may be that it's not convincing enough to show that you had acted in a way which was discrimination, for example. So in the round, I think you need to weigh up basically what's the issue in hand that you're trying to resolve. Are you going to rely on the Section 111A or the without prejudice rules, or a combination of both? And are you genuinely trying to resolve this issue and pitching the settlement at a level which is going to be attractive to the employee? Because if you're not, you potentially run the risk that they reject your offer and go ahead and make a claim, and then bring those discussions to the attention of the employment tribunal. Of course, it's always recommended that you get advice about the specific circumstances of the case that you're dealing with. If you feel like you need to have those discussions and you're not really sure how to approach it, you're not really sure how to pitch the level of the agreement or the offer that you're making, then it's always worth getting some specific advice from a solicitor or legal professional who can advise you fully about the law here. And I tell you, it can absolutely save you tons of money in the long run. The amount of times that we are instructed too far down the line to kind of salvage things enough for the employer is unbelievable. Actually, if they just come to us at the beginning and sought advice from the outset, they could have saved themselves a ton of money. So as I say, the second thing to take away from this is it's always important to get advice if you think that you're at risk of a potential claim or that you're worried about a potential claim from an employee in the future. Of course, if you have any questions about this, or you want to discuss anything that's contained in this episode, or you have a case that you want dealing with, please do not hesitate to contact me. My email address is alison@realemploymentlawsadvice.co.uk. You can always phone the office. The head office number is 01983 897 003. And I will call you back if you email me, or we can arrange a time to have a chat that's convenient for you. So do please get in touch. And of course, you can always connect with me on LinkedIn. I'm on there all the time, so it's great to connect with you, and I post updates and that kind of thing. So it'd be lovely to connect with you. Thanks very much for listening to this week's podcast. I hope you found it helpful, and I hope that you have a fantastic rest of the week. Thanks again for listening. Just want to finalise by saying I wouldn't be a lawyer unless I had a legal disclaimer. So I must just say to you that the information in this podcast is for information only. It's general review and a general update. It's always necessary to get specific legal advice about your circumstances. So please don't rely on anything that you've heard in this podcast. But please do feel free to contact me if you'd like further information or specific advice.